I have two motions to recuse. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. Bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time.
We assert not a bare assertion or a legal conclusion, but we make facts. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list.
What it do, what the business is, people? It's your boy That Way with Jack Travis to be precise, man. You know how we do, you know how we doing it. Back in that thing, gang, you understand me, man? Hey, we still on this Young Thug. Man, I can't get off of it. I thought it was gonna just well, I guess I didn't think it was gonna bypass, man. Like, to give you all a recap. Alright, so we already know that Thug was locked up and all that, but all the heat started with Lil Woody being on the stand. Lil Woody been snitching for about 10 years. He's fired a lawyer here lately. The smoke started because he was apparently in a meeting with the prosecutors and the judge. Thug's attorney found out about it, called him out on in court a couple days ago. Judge put Attorney Steele into 20 days of jail to be served 10 weekends straight. Judge Steele calls in Ashley Merchant. Ashley Merchant gives the judge all the business. File papers to recuse him. Supreme Court steps in, overturns or at least stalls out the confinement for Attorney Steele. And this is where we are. Alright. So that's where we are, man. We've got new footage. Now, you know what I'm saying? A lot of gotta do better, bro. I can't even care. Like, what's going on? They already look down on him, man. You know what I'm saying? They don't look down on him. It's an exclusive little spot. You dig what I'm saying? It's a lot going on. But as far as the people that's in power over there, man, you know, you coming off the Fannie Willis deal. The mayor's always over there on some bullshit. So it's just a bad look, man, for these people to be in these prominent places. You know what I'm saying? These high-level individuals and just getting their hands caught in it. I don't understand this judge. I don't know if maybe he's trying to sabotage the case, man, because I don't understand the moves he's making. And we haven't got into the gist of the video yet, and I'm not going to spoil it. You dig what I'm saying? I'm just going to let it do what it do. But that was a refresher course on where we are, man. I'll get into my thoughts later on, but let's jump into the first part of this video, and let's let the judge kick it off. Let's go.
First order of business the court needs to take up this morning. I have two motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Ms. Novay, Ms. Mormon, and Mr. Winchester.
All right, good morning, counsels. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently another a copy of that, or?
We did not, Judge.
Okay, no harm, no foul, no. So, no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit, if are true, recusal would be warranted. And that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it was it sworn before a notary is in proper form. I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
Yeah, so, okay. Where we are right now. Judge starts off the morning by saying he has two, and I think he knew that one was coming, right? He knew that one was coming from Attorney Steele, or I guess to be more precise, I almost called her Ashley back. My bad. Ashley Merchant. My bad. Ashley Merchant on behalf of Attorney Steele, you know what I'm saying, about the contempt charge. And by the way, the Supreme Court did away with that, or they stalled it out, or what have you. They stepped right in, and that's big. That's important. But he got a surprise. And before I get into the next set of clips, I'm gonna play. You'll see someone come up before Mr. Steele comes up and says what he has to say. But he starts out now. I mean, it's already a conflict of interest. You know, Ms. Merton told him in the last video, if you checked out my last video and you like what I'm doing, like and subscribe. You did what I'm saying. But in the last video, she informed him that he was not able to preside over the case. Now, if you catch the slick motion, what he's trying to do, the finesse game, he's trying to dismiss both of these cases just not on its face because they were filed properly. They were filed in time. But if you caught him, he said that, you know, sometimes in the Odyssey system, which apparently is the legal law system over there, papers may take, you know, 3-4 days to get put into the system, or maybe it's like a over the weekend thing. He told them that they had filed their motion on Friday evening, and it just got put into the system on Monday evening, somewhat what have you. You saw the court clerk, or the court reporter, I should say, was looking a bit flabbergasted, man. But yeah, he's trying to rule over a case that they already informed him that he's a witness in. The entire court, everyone that was in on that meeting is a witness. So you can't dismiss it. You understand what I'm saying? You making dismiss this other one, in which we hadn't got into the parameters of that, man. But just understand what we're saying. We already know what the judge did. How he got himself involved in this case. I don't really know what he's got going on with the prosecution. And now that he's received the items for him to be recused, you know, I think he's obligated to read them. But I'm not sure about the limits to his power when it comes to quashing those, as you heard him refer to. I don't know that he has that power, and he's informed of that later on in the video. So that later on in the video is coming now. So now let's get into the next part of what were the replies to Mr. Judge Glanvilee had to say. Let's go.
If I could just briefly be heard, Judge.
Sure.
Court, please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for abuse of discretion.
Certainly understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertains or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record. Okay.
All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not gonna, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver's gonna prepare the record. She does that, and like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
All right, man. Down South Johnny Cochran told him that he was not at all happy with the court's decision. They'll proceed accordingly. He did not appreciate the characterization of the accusations from the judge. He went into telling judge what Mr. Steele eventually got in his bag about, and it was the fact that the judge, he does not have the legal authority to preside over a case in which he's a witness. He doesn't want to cop to that fact. He keeps trying to cut. Well, at least he was doing that to Lil Johnny Crockett. I don't even know what the name. I hate to keep calling him Lil Johnny. But he was jumping in, wouldn't let him finish. And I guess when it comes to, what's going on in the courtroom now and who's got the flavor, neighbor, you dig what I'm saying, man? He doesn't really have to entertain, because the black guy represents attorney Bumpus. She was Lil Woody's attorney. And she wanted off, and I think, she was, I'm not really even understanding the parameters of her document, but that's it's beside the point. But I guess it carries weight when you see that there's two of them, on them at the same time. So I guess that was just made for document purposes. You dig what I'm saying? But when it came to Attorney Steele, you gotta love him, man. You know what I'm saying? Now, you say what you will about defense attorneys. You know what I'm saying? Now, I've had little debates in my head. I don't know that I've actually talked to anyone, but I'm like, you know what I'm saying? It's like a big deal. But defense lawyers are generally looked at as some sleazeball individuals. You dig what I'm saying? Because they represent a party, whether they're guilty or not, even if it's obvious that they're guilty of heinous acts. You dig what I'm saying? They still represent them. So, you know, they don't have such a, you know, they're well paid, so I guess they don't care, and I guess they can sleep at night about it because they're upholding their duty that they swore to uphold. But, you know, that's a hell of a game, man, because, again, it's people out here to do crazy things. Like, think about the code, what was it, Brian Kohlberg, whatever, up in Idaho, that's accused of doing that, you know, those things to those 4 college kids, you know what I'm saying? Like, but he has defense lawyers, you know what I'm saying? Now, he could be innocent. Looks like he's guilty, but it was just an example to say, you know, this is what defense lawyers do. So, but, you know, in this particular case, man, say what you will about what you think about Thug and what he's actually culpable of. You got to commend Mr. Steele. Because now he in his bag. Now he ain't afraid to talk to the judge. You see how he snatched his glasses off? Shit, this up and this stuck up there. You dig what I'm saying, man? He's saying shit with his chest. He said, well, this not just some basis, some bare accusations, some bare minimum, bare bones. Nigga, this facts. What do you mean? The court is a witness. You can't rule on this case, man. This is an interesting play out. And I said, and I'll say it again, I think they're coming home, man. This has mistrial written all over it. And I would imagine that the judge is probably trying to buy as much time as he can. I don't know that he wants this thing to end anytime soon, because as fast as the Supreme Court stepped in and made a decision on that contempt confinement, that should let you know that they're tuned into this case and they're willing to make some special intervention. You dig what I'm saying, to rectify the wrongs being done in this court. I don't think they cared anything about Young Thug, but it's probably more so of a thing like they, you know, I don't know what the Supreme Court may have against a bias to anybody, but I know this judge over there with diamonds in his ears and chewing on peanuts or oranges or some shit all trial, doing all this tomfoolery, man. Like, you know, I can't vouch for it, man. So that's pretty much where we are, man. It develops. We'll see what happens as far as these, but as far as I know, the trial is going to just continue to go on. I'll tune in to it tomorrow, see what happens. But until then, man, y'all keep it safe, man. Holla at your boy. This has been That Way with Jack Travis. Loud.